Welcome to Module 2 of Week 1. This covers unauthorized practice of law, which too many times is done by financial planners and other people who really don't understand what unauthorized practice of law means. Too often people think it means they're going to court, where the most common type of problem, quite candidly, is not going to court, but giving advice to clients in an area you're not really authorized to give it, and we're going to look at it in the next few charts. The level of expertise and training determines what you can offer, and I think that's a safe way that keeps you away from the legal issues, because of the fact that you have to have the expertise and you have to have the training. In financial planning courses, you've taken a lot of subjects you've covered. The number of learning objectives is something like 80, and with those learning objectives you get a little bit of depth of knowledge, but not enough to really be an expert. For example, some of the material we cover, like the 303 and 6166 in this course, we cover in maybe half an hour. But if you were in trying to become an expert in it, you'd be taking a 3 or 4 day course. So we're going to find that the expertise and the training is a good guidance to keep you out of the trouble. And let's go over the financial reasons and legal reasons why financial planners should not take on legal issues. First of all, state law. State law says only attorneys can give legal advice to clients, and you must be a member of the state bar of that state. So if you're from, say, Nevada, you cannot tell Californians about California law unless you're authorized to do law in California. Lack of training. There's a considerable amount of training required for lawyers in all of the areas that cover legal documents and legal expertise. That includes 3 years of training in a classroom environment, as well as passing a very difficult bar exam. Another reason that you should not get involved is a lack of understanding of the legal aspects that could be impacted. You may know one rule very well, and for example, joint tenancy rights of survivorship, but you may not know the ramifications of giving that advice because you don't have all of the background you need in. And finally, the depth of knowledge, as I mentioned before, we get very little training as opposed to the depth that's needed to really understand it. And I look at this course, and most courses in financial planning is like the Platte River. For those of you in the Great Plains or have driven through the Great Plains, the Platte River seems to twist its way and snake its way from the Colorado area to the Mississippi River. And if you're going over the highways, you're going to go over it maybe 20 times because it just snakes along. That river is always very shallow but very wide, and that's the kind of expertise we have as financial planners. We have a very wide expertise, but a very shallow expertise. And what is needed for the legal practice, or doing any type of practice, is depth. Now, how do we avoid the unauthorized practice law? First of all, we can give our clients copies of common literature. For example, my office has rules law that are on little 3x5 cards. Also, if there's a news article or a magazine article that has been approved for our use and distribution, we use that to give to clients that describes the type of rules that are involved. Again, this is general information. It doesn't say how it applies to the client, and that's the key when you're giving common literature. It is a set of rules, not how they are applied. Second, we always suggest you need to see an attorney to answer specific legal questions. We can give you the general statements, for example, what a joint tenancy is and what a tenancy entirety is on little cards, but you need to have a lawyer explain how they relate to each other and the ramifications. Third, we can review and suggest legal assistance for wills, trusts, and other legal documents. For example, you might give a client a list of the things that should be in a will or in the trust or other document But again, it's going to have to be the lawyer who actually writes the will or other documents. My concern in many cases is when you draft clauses for the clients try to use the clauses and not seeing an attorney to save some money. Therefore, they may make some very bad decisions. So I try to be very general in what we tell them as far as the legal assistance. And then you can discuss general principles that are generally known. For example, you need to have a will or will substitute if you want to avoid probate. You should not drive over 65 miles an hour unless a sign is posted that allows you to drive over 65 miles an hour. You should, when you're driving on ice, you should have snow tires or chains. Again, general rules, be it from the IRS, from the Motor Vehicle Code, from the state probate code, doesn't matter. General principles are fine as well as they are generally well known. And again, you're not giving them, you need to have a will or you need to have this type of will substitute. Taxation advice. I would always remind the clients that most tax preparers are unlicensed and unregulated, and quite frankly, you, the client, are responsible for the tax bill and for the accuracy of the forms, not the tax preparer. It's very difficult for the tax preparers to get in trouble because the government considers the person who is a taxpayer being responsible. Therefore, you client needs to do due diligence before getting to use tax preparers who are unregulated. I recommend clients to see either enrolled agents or CPAs for qualified tax advice. Both of them are able to fill out the tax returns, and they can give you the references as well as be able to do the return for you and give you tax advice for them. I do not recommend they see an attorney. Attorneys really are designed when there is a controversy involved, and so that is where the attorney comes in. Attorneys really aren't prepared to fill out the tax returns. In fact, if you go see an attorney, he's probably going to have that return prepared by someone else who is a tax preparer rather than doing it themselves. You may have heard in the last few years that tax preparers were going to be regulated and licensed. That has gone out the window because of a court case. Therefore, again, I recommend that you always have your clients see an enrolled agent or CPAs for good tax advice. I may have had people in the past tell me that H&R Block is good. H&R Block are good at what they're good at, but they're not good at the type of problems that would be run into by a person who can afford to see a financial planner. That's the problem. It's a lower level. With that, if you have questions, contact me.